There are 4 things your HR department can do to you right now, today, completely within the rules, and every single one of them can cost you money, evidence, or your job before you even realize what happened. Most people don't figure out the game until years later, usually after they've already lost. And I want to warn you now, these get worse as we go. So if you only watch part of this video, you're missing the one that costs people the most money every single year. Stick with me. Hey, welcome back. I'm Dre. I spend my time studying how companies actually function behind the curtain, not the polished version they hand you in orientation, the real one. If that's useful to you, hit subscribe now, because I put out a new breakdown like this every week. And once you understand how this machine works, you stop walking into HR meetings blind. Let's get into it. Trick number 1, the open door that isn't really open. Almost every employee handbook in the country has some version of this line. HR maintains an open door policy. Bring us your concerns. Most employees read that and assume it means 3 things: that HR is neutral, that their complaint stays private, and that they're now shielded from retaliation the moment they speak up. None of that is guaranteed, and in a lot of workplaces, none of it is even close to true. HR does not work for you. HR is a function of the company, funded by the company, evaluated by the company, and its core job is to reduce risk and liability for the company. So when you walk into that office and share something sensitive, there is no rule requiring that stays between you and HR. In plenty of cases, that information moves straight to your manager, sometimes within the same day. And here's the part that really catches people off guard. The open door isn't always there to help you. Sometimes it's there so the company hears about problems early enough to manage them quietly before they turn into a real headache. That can mean smoothing things over, and it can also mean identifying who's about to become inconvenient. People who raise legitimate concerns sometimes find themselves written up for unrelated reasons a few weeks later, and eventually pushed out the door entirely. On top of that, a lot of employees are told, informally, that using the open door protects them legally from retaliation. That is not automatically true. Legal retaliation protection generally only kicks in when you've made a complaint about something specifically protected by law, like discrimination, harassment, unpaid wages, or safety violations, not just general dissatisfaction. Vague complaints about how you're treated don't carry the same legal weight. There's a reason this trick works so well, and it's not that people are naive. It's that the language is designed to sound like a safety net. Words like open door, confidential, and safe space carry a lot of emotional weight, and companies know that. It feels almost rude to question them. But policy language in a handbook is not a binding legal promise. It's a description of process, written by the company for the company's benefit. None of this means you should never go to HR. Sometimes you absolutely should, and doing it the right way, in writing, with specifics, referencing the actual policy or law being violated, can genuinely protect you. But you need to understand what you're actually walking into before you do it, because the open door swings both ways, and you want to make sure you're not the only one walking through it unprepared. Trick number 2, the investigation that was never about finding the truth. Picture this. You go to HR and report a coworker or a manager for something serious, harassment, discrimination, whatever it is. The rep listens, nods, takes notes, and tells you they're opening a formal investigation. That sounds reassuring. Here's what's actually happening behind that reassurance. There is no independent due process inside a private company. The investigation isn't a search for facts, it's a risk assessment, and its real client is the business, not you. In practice, this can look like the notes from your original meeting getting summarized or discarded rather than preserved word for word. It can look like witnesses being selected based on who supports the company's version of events, while people who'd corroborate your account never get interviewed at all. It can look like every conversation moving to phone calls or in-person chats instead of anything in writing, so there's less of a paper trail if this ever ends up in a courtroom. And very often, HR quietly starts working with your manager to begin documenting your own performance, building a file that can be used against you later if you decide to escalate. Then, weeks later, the investigation wraps up, and the conclusion is almost always the same: insufficient evidence of wrongdoing. Even when the person handling it privately believes you, putting that belief in writing creates liability, and their job is to minimize liability, not validate your experience. On top of that, most companies operate on at-will employment, which means in the absence of a contract or a specific legal protection, you can generally be let go for almost any reason, or no stated reason at all, as long as it isn't an illegal one. That gives a company enormous room to distance itself from you quietly in the months after an investigation, without ever having to connect the dots publicly. Does that mean you should refuse to participate or stop bringing legitimate complaints forward? No. If this situation ever turns into litigation, a jury is going to look at how you behaved throughout the process, and non-cooperation reads badly, regardless of who was actually in the right. So participate, document everything on your end, and always ask yourself one question before you act. How would this look to 12 strangers on a jury? If this is opening your eyes a little, go ahead and subscribe now, because Trick 3 and Trick 4 are where this really gets uncomfortable. And Trick 4 alone has cost American workers billions. Trick number 3, the manufactured paper trail. This one usually shows up right after you've done something the company didn't want you to do. Filed a complaint, asked about overtime pay, requested medical leave, whatever the trigger was. Suddenly, out of nowhere, you start getting written up. You were late, even though you weren't. You had a bad attitude in a meeting, even though nobody said anything at the time. You missed a deadline that was never clearly communicated in the first place. Individually, these write-ups look minor, almost forgettable, but they're not random, and they're not really about your performance. They're building a file, a documented history designed to make your eventual termination look like the natural result of poor performance rather than what it actually is, which is retaliation for something you did that the company didn't like. Performance improvement plans get used the same way. On paper, a PIP looks like a genuine second chance. In practice, plenty of them are written to be unwinnable. Vague targets, unrealistic timelines, moving goalposts, specifically so that failure is guaranteed and documented. Sometimes the timing alone tells you everything. A spotless review one quarter, followed almost immediately by a sudden string of write-ups the moment you become inconvenient in some other way. By the time you're let go, there's a tidy folder that tells one version of the story, and you're the only one who knows the other version even exists. The move here is simple but powerful. Get everything in writing. If you're written up for something you disagree with, respond in writing, calmly, factually, with your own account of what actually happened, dates and all, and keep a copy for yourself. Not just what's in your work email, somewhere you control, like a personal drive or your own inbox. Build your own file before they finish building theirs, because the version of events that's written down is usually the version that wins. Trick number 4, and this is the one that quietly costs workers the most money in this entire country every year: forced arbitration. Most people have never even heard this term, and that's part of why it works so well. Here's how it typically happens. You accept a job offer. You're excited. HR hands you a stack of onboarding paperwork, and somewhere in that stack, sometimes as its own document, sometimes buried inside the employee handbook you're asked to acknowledge, is an arbitration agreement. Nobody reads the whole handbook. You sign it because you just want the job. And if you push back or refuse, some companies will simply pull the offer. So what does signing it actually mean? It means that if you ever have a serious legal dispute with your employer, wrongful termination, unpaid wages, harassment, discrimination, you give up your right to bring that case to a public courtroom. Instead, you're funneled into private arbitration, a closed-door process where a single arbitrator, usually a retired judge or a former defense side attorney, acts as judge and jury. That arbitrator is often paid by the hour, by the company, case after case, which raises an obvious question. How motivated is that person to consistently rule against the party that keeps hiring them? Researchers who study dispute resolution have pointed out for years that outcomes and award amounts in arbitration tend to skew more favorably toward employers than comparable cases resolved in open court, which is exactly why companies prefer it. A widely cited study from the Economic Policy Institute found that a majority of private sector, non-union employees in America, well over half, are bound by mandatory arbitration clauses, which works out to tens of millions of workers. Among the largest companies, the ones with 1,000 employees or more, that number climbs even higher, past 60%. This same mechanism often shows up again later in your career, wrapped inside a severance agreement when you're finally let go, where signing away your right to sue is quietly bundled together with your last paycheck. And it gets worse, because most of these agreements also include a class action waiver, meaning you can't band together with coworkers who experience the same violation and sue as a group. Here's why that detail matters so much. Say your employer shorted you $5,000 in unpaid overtime. On its own, that's real money, but it's not enough to make hiring a lawyer worthwhile once you account for the cost of pursuing a case. Alone, it often just doesn't get pursued. But if 100 employees at that same company were shorted the same way, a class action becomes financially viable, and suddenly the company faces real consequences. Block the class action, and all those smaller claims quietly disappear, one at a time, never pursued, never recovered. Researchers studying wage theft in low-paid industries have estimated the losses tied to this exact mechanism run into the billions of dollars every single year. Quick note here, I'm not your attorney. This isn't legal advice. Employment law varies significantly by state. So if you're dealing with something like this, talk to a licensed employment attorney where you live before making any decisions. But at minimum, know this. Before you sign anything on your first day, ask whether there is an arbitration clause. Ask whether it includes a class action waiver. And understand that once you sign it, walking it back later is extremely difficult. So here's the bigger picture underneath all four of these. I don't think most people working in HR wake up trying to hurt employees. Most of them are just doing the job they were hired to do, protecting the organization that signs their paycheck, inside a system that rewards them for minimizing risk to the company, not for making sure you're treated fairly. The problem isn't that individual people are villains. It's that the entire incentive structure is built to favor the company over the person sitting across the desk from them. And no amount of friendliness in that first meeting changes who's actually paying the bill. Once you actually understand that, you stop assuming HR is your ally by default and you start making decisions accordingly. Documenting things as they happen instead of trying to reconstruct them later. Reading what you sign instead of skimming it, and knowing exactly which of your rights are protected by law versus which ones only sound protected because a handbook used a comforting word. If this helped you see your workplace a little more clearly, subscribe, because next time I'm breaking down exactly how to file a complaint the right way, so it actually protects you instead of quietly getting used against you later. Drop a comment and tell me which one of these 4 surprised you the most. I read every single one. Take care of yourself out there.